In honor of those who have made the ultimate sacrifice for our wonderful country, Brother Counsel Studios will not be posting any videos on Memorial Day. This video is going to be posted on Tuesday at 12 a.m. Eastern. The Karen Read case and trial is no doubt going to be a case study in the future. Law schools, lawyers, judges, and legal scholars are going to be poring over the details and the trial in this case to try to figure out, for one, why a certain verdict resulted. Now, as I said here today, we do not have a verdict in the Karen Read case, although the prosecution is about to wrap up its case in chief. By all the reports, the prosecution has only one more witness to call, which is why I felt comfortable enough to show you the following presentation. This presentation is going to break down some of the mistakes and errors that the prosecution made in its case, which, if the verdict is going to be a not guilty or a hung jury, these are going to be what I believe are the main reasons for that. Now, if the verdict comes back as guilty, it's not going to be because of these reasons, but despite these errors that the jury comes back with a guilty verdict. So let's jump into it right now. Karen Read Trial 2.0, how to lose a trial in 20 days. There's been 20 days of trial so far, and these, what I believe, are the biggest mistakes that the prosecution has made so far. Number one, ignore your weaknesses. That is mistake number one. There is a very big problem in this case, and that is former Trooper Michael Proctor. Former Trooper Michael Proctor was dishonorably discharged in this case. He sent some vile text messages. He was investigated, and eventually he was fired. Now, if you're the prosecution, you've got to frame that in your way for the jury. In this case, the prosecutor ignored that fact, and therefore, Alan Jackson, in his opening statement, right away mentioned to the jury that the prosecution deliberately ignored Michael Proctor in this case, although Michael Proctor was the lead investigator in this case. Called Michael Proctor a cancer, and that Michael Proctor's fingers are all over this case as the lead investigator. Now, he also spoke about Brian Albert. This is, again, the defense and not the prosecution. The prosecution did not speak about Brian Albert. Brian Albert was the owner of 34 Fairview, the home there, and he is also the owner of Chloe. Brian Albert famously made some butt dials and some butt answers at around 2 o'clock in the morning after the time when John O'Keefe was dead or dying on the lawn. Also, he owned his dog, Chloe, and when looking at some of the pictures of John O'Keefe's injuries, specifically to his arm, which definitely could be argued that they're from a dog, well, that was not mentioned at all by the prosecution either. And the fact that Chloe was rehomed after this incident. Also, the fact that Brian Albert sold his house after this incident. Brian Higgins was not mentioned in the prosecutor's opening statement, and Brian Higgins had a flirtatious relationship with Karen Read, and then was ghosted about a week before this murder. Perhaps that could be some motive. Lucky Lawford was not brought up in the prosecution's opening statement. Lucky Lawford was the plow driver who passed by and did not see a body there when the prosecution's theory is that the body was there. Also, Lucky Lawford passed by later and saw a Ford Edge in front of the house, and the Alberts own a Ford Edge. Also, the fact that Dr. Scorty Bello, in her death certificate, she is the medical examiner in this case, and she listed the manner of death to be undetermined. Also, the fact that nobody who was in that house left that night after John O'Keefe's body was allegedly lying there. No one reported seeing John O'Keefe's body there, who was 6'2", over 200 pounds, and there was not significant snow on the ground yet. Also, this Google search of how long to die in the cold was not discussed. All of these issues were not mentioned at all by the prosecution. Now, regardless of the merit of any of these arguments, if you're the prosecutor, you've got to get out in front of this and you've got to frame it in the way that's going to help your case in the future. And it simply was not done. Okay, and I also am going to include the links to the specific days in trial where we're discussing how what the specific issues were. So here you see the first link. Next error, mess up the timeline. Okay, this is something where Hank Brennan in his opening statement, his timeline did not make sense. It just didn't add up. And again, if you look at that, if you click on that link, you'll see exactly what I'm talking about. He says that at the 3-point turn happened at 12:23, or before 12:23, which was 7 minutes before the collision. And then he says that the Lexus reached the flagpole at 12:34:33. Now, some people said, well, he misspoke. He really meant to say 12:24 and 33. Well, first of all, you cannot mess up the timeline in this case. In this case, literally seconds matter. And therefore, if you're going to mess up anything in this opening statement, it cannot be the timeline. If you're going to misspeak, you got to correct it. So that was First problem, even if he misspoke and said 12:34 instead of 12:24, that's something that you cannot have in this case. Number two is that even if you add the times together, 12:23 plus 7 minutes is 12:30. And in the common Wilson theory, the collision happens 12:32, which is more than 7 minutes after. So the timeline is all over the place and it doesn't add up. And that's another problem with the prosecution's case. Continuing, if you promise evidence that you don't produce, in the opening statement, you're going to tell the jury what you are going to show them in your evidence with certain testimony. And this is a quote that Hank Brennan said in his opening statement. He said, Jennifer McCabe and others, and here's the link. You can take a look at the link. It's right there. Jennifer McCabe and others looked out the window and see the defendant's Lexus in front of the flagpole at the far end. Now, they're the only witness that testified that they looked out the window and saw the Lexus was Jennifer McCabe. There was no other testimony from anybody else in the house who said that they looked out the window and saw the defendant's Lexus there. Now, there was some testimony that Ryan Nagel, who was in a car outside, saw the Lexus, but there was no testimony, and also Heather Maxim, but there was no testimony from anybody in the house who looked out the window who said that they saw the defendant's Lexus in front of the flagpole at the far end. It just didn't happen. So this is overpromising and not producing. Moving on. Allow the defense to bring out damaging information on your witness. If you have bad information on your witness, you have to be the one to bring it out. So when Carrie Roberts got on the stand and she testified in the grand jury that she heard Karen Reed tell Jennifer McCabe to Google how long to die in the cold, you cannot let Alan Jackson on the defense bring that out for the first time and let the jury hear it from him on cross-examination. That's what you cannot do. You've got to get in front of all this. You've got to ask Carrie about the grand jury testimony. You've got to impeach her, even though she's your own witness, because you're going to do it in a lot softer way than Alan Jackson. If he gets up there afterwards and tries to reiterate the same point, okay, the jury already heard it from you. Moving on. Again, same issue, allowing the defense to bring out damaging information on your witness. Well, let's talk about Jennifer McCabe. Jennifer McCabe, she didn't tell, and these are just a few of them. She didn't tell the grand jury that Karen Reed said, I hit him 3 times. That's a very important part of this case because it's not in any sort of police report that Karen Reed actually said affirmatively that she hit him. There's some questions about whether she hit him or I hope I didn't hit him, but that doesn't appear in any sort of report or any sort of medical record anywhere. There's no report that says that Karen Reed said I hit him. So you just have Jennifer McCabe's testimony. You also have some Timothy Nuttall and you have Kate McLaughlin. So here, Jennifer McCabe did not tell the grand jury that. If you're the prosecutor, you have to be the one to bring that out. Don't let Alan Jackson do it because he's going to make her look like a much bigger liar as opposed to when it's your witness. You're going to be much more gentle with her. Number 2, the fact that she forgot to tell the grand jury and the police that she called Nicole Albert at 5:07 a.m. That's, again, something else that she forgot to mention, which is an important fact. Why would she feel it's necessary to call Nicole Albert when Karen Reed is calling her frantic that she doesn't know where John O'Keefe is? She forgot to say that. Number 3, she forgot to tell the federal investigators, even though they were not allowed to mention that during the trial that it was a federal investigator, but she testified that she forgot to tell them that she also called 3 other people during the 10 minutes before they came. Meaning they called her and said, we're coming over. We need to speak to you. And she said, okay, give me 10 minutes. And she testified that she told them that she called 2 people, but she forgot that she also called 3 additional people. Peggy O'Keefe, the DA's office, which she says is the witness advocate, and Brian Albert. So again, if this is going to come out and you know it's going to, then you as the prosecutor have to bring it out. And when you let the defense bring it out, they're going to make her look like a much bigger liar than if you bring her out and then you can play it down as something that she forgot or whatever it is. Moving on. Deny the obvious. If you try to deny the obvious, what's absolutely going to come out in this trial, then you're just going to look like you're trying to hide from this information. And it's not a good look to the jury. So in this case, Michael Proctor was the lead investigator. It's coming out. It's going to be clear to the jury by the end of the trial. Why try to deny it? Why try to hide behind it? So you have Paul Gallagher, who tried to stay away explained that Michael Proctor was not the lead investigator. You've got Yuri Buchanan trying to say that, no, he's only a case officer. He's not a lead investigator. And then you got Connor Keefe saying that he was the lead investigator. And you have Maureen Hartnett saying that he was the lead investigator. So this is trying to deny the obvious. Don't go that way. Just acknowledge it, that yes, he was a lead investigator, but still, if you're the prosecutor, you have to make the case that although he was a lead investigator and he messed up in certain ways, but the other parts of the investigation is still good and still credible. And by trying to deny it with these witnesses, it's not going to look good. Let's also remember that Yuri Buchanan, we're going to see about this a little bit later, but Yuri Buchanan is supposed to be the saving grace for Michael Proctor. He's supposed to be the supervisor and trying to be the one who was not the one that was acting with misconduct and not the one showing bias. He's the one that had some detail with the president. Whatever. You gotta build him up. And when he starts to deny these things also, it's just going to take away some more of his credibility. Try to excuse instead of own poor choices. We heard about Paul Gallagher in day 9. And again, all the clips are right here. You can take a look. So you got Paul Gallagher who said about the solo cups, instead of saying, yeah, I guess it was kind of stupid of me to do the solo cups, he just says, no, they hold liquid terrifically. And then you have Maureen Hartnett saying that it was the first time she ever had to take swabs from solo cups. And she never in the future ever took swabs from solo cups. Then you have Paul Gallagher again saying that the Stop and Shop bag, trying to argue that it's the same as an evidence bag. Of course it's not. Just own up to the poor choices that you made in the investigation, and then it doesn't look like you're trying to convince the jury of something that's ridiculous. So that's another problem. Moving on. Use your own expert to discredit your arguments. So this is when Hank Brennan got up with Dr. Scardi-Bello and asked her if she was aware that there were reports that Karen Reed said, I hit him 3 times. And she actually acknowledged and said, yeah, I did know that before I ruled that this manner of death was undetermined. So he completely shot himself in the foot by asking that question and not knowing what the answer is going to be. And that's going to take away a big part of his argument. A big part of his argument here is that Karen Reed admitted that she hit him. And still, despite that admission, if you want to call it that, Dr. Scardi-Bello still was not able to rule that this was a homicide. And therefore, the argument could be made to the jury, well, are you any smarter than the medical examiner in this case? Dr. Scardi-Bello, she did not know what the manner of death was. And Hank Brennan, was the one who brought this out. Continuing. Hire experts with no credibility. Well, if you remember Shannon Burgess, and the Aperture website lists his CV as having a bachelor's and his LinkedIn profile, and then the hyperlinked LinkedIn page is disabled. There is absolutely no bachelor's of general science from the University of Alabama, and he's been pursuing this bachelor's allegedly for 17 years. Okay, he had no credibility by the time that he was done. So when you hire experts with no credibility, you don't do your homework, making sure that these experts are going to be good for you on your case and reviewing what you need in their CV and making sure that they have what they need in order to be considered an expert and not to lose all credibility with the jury, well, then you're going to see what happened with Shannon Burgess. So that's another problem that the prosecution had with this case. Now, another issue is the fact that you destroy the next expert's credibility before they even take the stand. Dr. Welcher did not even take the stand yet. And because he is the VP of Aperture and that he works for Aperture, and the jury just heard about how Aperture essentially held out to the public something that was not truthful, that some of their experts have certain credentials which they really don't have, and now you're calling another person that works for the same company, it's not going to look that great to the jury. So the jury, when they hear that Dr. Welcher works for Aperture, right away they're going to associate that with everything that happened with Shannon Burgess. So the prosecution actually destroyed their own expert's credibility, Dr. Welcher, before he even took the stand. And it cannot be understated how important Dr. Welcher's testimony is for this case. After all, it comes down to the ARC experts in the first case. The ARC experts testified in the first case that the collision, this alleged collision between the Lexus and John O'Keefe, are not consistent. The damage to the vehicle and the injuries to John O'Keefe are not consistent with one another. Dr. Welcher was supposed to come into this second trial and save the day for the Commonwealth and be this extremely brilliant accident reconstructionist who's able to take on ARCA experts and explain how really this all could have happened. And we're probably going to see that. That's the last witness that the prosecution is going to call by the reports that we're getting. And before he even takes the stand, he's already tarnished by what happened with Burgess and by what happened was what was shown with Aperture's website and listing certain credentials of experts that they don't really have. So Dr. Welcher is supposed to be this untouchable expert, and he's already taken the stand already with this problem on his hand, already not with problems with credibility. Instruct crucial witnesses to be evasive. Jennifer McCabe, Yuri Buchanan, these are the witnesses that didn't remember anything. Jennifer McCabe had to be reminded of everything. And then when they tried to jog her memory, she still didn't remember anything. Only certain parts she remembered. And that was, as we saw, play out with her. Now, again, like I want to say about Jennifer McCabe, she did a lot better this time testifying than she did in the first trial. Everybody would agree with that. But still, by the time that she was done testifying, the jury had the sense, they must have had the sense that this is a witness who's trying to be evasive. She's trying to be difficult. Even though she's doing it with a smile and saying, I'm sorry, and saying thank you, still, it's a witness who's trying their hardest to not be forthcoming. And that's the sense that the jury could very well have gotten. Yuri Buchanan, his testimony should have lasted a day and a half. Instead, it lasted 3 days because he couldn't answer a question with a yes or no. And he couldn't answer simple questions. And he was fighting back and everything. And at one point, he asked Alan Jackson to get him at Webster's Dictionary to define a term that he used, which the term was theory, by the way. So Yuri Buchanan, who is supposed to be, again, the saving grace for Michael Proctor. Michael Proctor, you want to throw under the bus, fine, but then you got to have somebody. So who are you going to point to the jury to say, well, you're right, Michael Proctor wasn't a great guy, but we have, enter who? Yuri Buchanan? It was terrible on the stand. And the jury saw that after 3 days, not refusing to answer a question in a normal way. So that it can't be understated how destructive the testimony from Yuri Buchanan was to the Commonwealth's case. And Jennifer McCabe, even though she did a lot better than the first trial, but still at the end of the cross-examination, you can tell that it was just one long testimony of evasiveness. She's just being too evasive, and the jury picks up on these things. Finally, don't call witnesses that hurt your case and let the defense call them. This is, again, another problem. Michael Proctor, Brian Albert, and Brian Higgins, from the reports that we're getting today, now maybe this will change by the time this video comes out, but from the reports we're getting, the Commonwealth is not even going to call Michael Proctor. And it cannot, again, be understated how colossal that mistake is. And to not call Brian Albert and to not call Brian Higgins. You've got to get in front of these people. You got to present them to the jury with all of their problems, with all of their blemishes, and say, look, we have to present the case to you. And in fact, in closing, you can tell the jury, I didn't want to call Michael Proctor. You think I wanted to ask him about all these text messages and the fact that he's dishonorably discharged, but I wanted to present you with all of the evidence. I wanted to present you all the good, the bad, the ugly. I didn't want to just pick and choose what evidence to show you. If you do that as a prosecutor, you come across as much more believable. The jury will sympathize with you. But if you try to hide all of this negative information, all these witnesses are going to hurt your case. If you try to hide them, and then the defense actually calls these witnesses, this alone could ruin your case for you. This alone, the jury can decide you're not telling us the truth. You're not being forthcoming. We don't know what else you're hiding, and we're not going to convict because you're not being honest. You're not showing us all the information. This alone, I think, is so detrimental to the Commonwealth's case. This alone could result in a not guilty verdict. So that is what I think are the main reasons why, if this case, again, we don't know what's going to happen, but if this case ends up as the verdict ends up as a not guilty or a hung jury, those are the reasons that I believe are the main reasons why it would result in a not guilty or a hung jury. So, and we haven't even seen yet the defense's case even yet. So that is going to be my take. I left all of the hyperlinks in the presentation, so you can go look up all of those clips of the testimony that I'm referring to, and you can see for yourself. So that is my take on this, and that's going to be it for today. So we will see you all back here for the live stream starting Tuesday morning, actually at 9 a.m. And of course, we'll have to recap Tuesday. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.